Oh, man, it's hot in the hallway and there's no waiting. It's crazy hot.
All right, where is the family violence file? All right. The one that Bridget Garza has.
Oh, not the first row. Okay.
Bridget Garza, who's your client?
For Daniel Flores.
All right. No. Thank you. All right. Can I see the parties on Daniel Flores? All right, I will walk you through the plea. Court is calling 2021 CR 9660. I'm sorry, you all gonna have to be quiet behind the court reporter. You can move down there. Court is calling 2021 CR 9660, State of Texas versus Daniel Flores. Can I have parties announced for the record for the state?
Ruben Herrera for the state.
Defense?
Bridget Garza for defense.
Are you Mr. Flores?
Yes, ma'am.
All right, counsel, have you received all the discovery and did you review that discovery with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Showing you what's entitled True Bill of Indictment. Did you review that with your attorney? Did you understand it? Counsel, do you waive the reading of the indictment?
Yes, Your Honor.
State, are you requesting to amend the indictment? Yes.
Yes, Your Honor.
Thank you. All right. Defense, have you had a chance to review the state's request for the amendment of the indictment?
Yes, Your Honor.
Mr. Flores, have you had a chance to review the request for the amendment of the indictment?
Yes, Your Honor.
State, defense, do you have any objections to amending the indictment?
No, we do not.
Mr. Flores, do you understand that the indictment as amended is a substantive change to the indictment?
Yes.
And do you understand that your attorney has 10 days to prepare for a trial with a substantive change?
Yes.
Knowing that, do you still wish to proceed?
Yes.
All right, then the court will grant without objection, the court will grant the state's motion to amend indictment. State, my understanding is that you're proceeding on count 7. Is that correct?
That's correct, Your Honor.
Mr. Flores, I'm showing you what's entitled court admonishments and defendant's waivers and affidavit of admonitions. Did you review that with your attorney? Did you understand it?
Yes, Your
And
Honor.
did you sign it in all the appropriate places?
Yes, Your Honor.
Excuse me, could you do a file stamp on that, please? Did you understand in count 7, you're charged with the offense of indecency with a child by exposure? That's a 3rd-degree felony. The range of punishment is anywhere from 2 to 10 years in prison and up to a $10,000 fine. Did you understand?
Yes, Your Honor.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, Your Honor.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, Your Honor.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes.
And did you intend to give up those rights and enter into a plea in this case?
Yes.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 10 years in the prison?
Yes, Your Honor.
Counsel, has your client been able to provide you with any defenses?
Yes, Your Honor.
Do you believe he has a rational as well as a factual understanding of the charges against him?
Yes, Your Honor.
Do you believe he's currently competent and was legally sane at the time of the offense?
Yes.
Mr. Flores, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, Your Honor.
Has anyone promised you anything other than the plea?
No, Your Honor.
Are you satisfied with the way you've been represented?
Of course, Your Honor.
Are you a U.S. citizen?
Yes, Your Honor.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, Your Honor.
According to the plea, the state is proceeding on count 7, indecency with a child by exposure. There's a $1,500 fine. State recommends deferred adjudication. There's to be restitution, if any, to the complainant for medical and mental health expenses. And there's to be Chapter 62 registration and no contact with the complainant. Did you understand that to be the plea?
Your Honor.
Defense,
Yes.
state?
Yes.
Showing you the waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, Your Honor.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is requesting that your deferred adjudication be for a term of 5 years. Did you understand that was a recommendation from the state and the court does not have to follow that recommendation?
Yes, Your Honor.
Then to the offenses charged in count 7, how do you plead? Guilty, not guilty, or no contest?
No contest.
State, any evidence?
State offers State's Exhibit 1 in all of its attachments.
Any objection?
No objections, Your Honor.
Showing you what's entitled waiving consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? And did you sign it in all the appropriate places?
Your Honor.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, Your Honor.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports, but most importantly, there will be no live testimony? Did you understand?
Yes.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence State's Exhibits 1 and attachments and review the same. All right, after reviewing State's Exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Why should I accept this plea? Has anyone spoken with the complainant?
Yes, Your Honor.
For the state, Your Honor, we have spoken to the victim. Well, I can say that in conferring with Ms. Garza, she has provided me a lot of materials. I think ultimately, to be frank, she's not happy with the agreement, Your Honor, but I think given everything that Ms. Garza has shown me and other factors that came about not conferring, this is the best result.
Judge, there was a lot of, the reason why we came to this resolution is because there is a lot of issues with the complainant. That is why the state of Texas and I came to this resolution. It was going to be a difficult case for the state of Texas because of the complainant, because of the issues that the complainant has. So this was the best resolution for the state and for us.
Okay. All right. Do you have any children?
No, ma'am.
Who do you live with?
My mom.
Are you employed?
Yes, ma'am.
What do you do?
I do landscaping.
Landscaping. I'm telling you, landscaping is the new West telemarketing. All right. 8 years deferred adjudication. There's a $1,500 fine. That will be probated. If you're drug tested today, what are the results going to be?
Be dirty.
For what?
Marijuana.
When's the last time you used?
Just the other day.
Why are you coming before the court and you're using drugs? That's a question. It's not rhetorical. It's a question. I'm sorry.
I have a lot of anxiety and stuff. So
There's to be no contact with the complainant. There's to be restitution to the complainant for any medical expenses. That includes mental health expenses as well. Chapter 62, registration. I'm going to want the UA hotline and for him to be tested for levels. You're not allowed to use marijuana. It's illegal in Texas. When you're on probation, their conditions are you cannot use marijuana or any type of controlled substance without a prescription. And you're not allowed to drink alcohol while you're on probation in Texas. You understand? There's to be regular reporting. He's to be monitored by the sex offender unit. Probation, is there anything else? All right, proof of employment within 45 days. There's to be no employment as a home health care or with minors. And there's to be no contact with minors. Is there anything else you need from the court?
man.
Showing you what's entitled trial court certification of defendant's rights to appeal. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I do.
Because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand? All right, we can go off the record. This is something you need to understand. Children cannot consent to any type of sexual contact. You know why? Because they're children. And you as an adult, I don't care if you're 21, 22, whatever age you are, Texas says that you're an adult. You understand?
Yes, Your Honor.
And calling some child over and over on their cell phone, that was a horrible thing to do. And did this take place at your mom's house?
Yes, Your Honor.
You don't even have your own place, and you're bringing nonsense to your mom's house. If you have any contact with children, you are looking at 10 years in the prison. Do you understand?
Yes, Your Honor.
If you violate any conditions, you're looking at 10 years in the prison. Do you understand?
Yes, Your Honor.
From here on out, everything you do, including smoking marijuana, you need to ask yourself, is this something that could potentially result in me going to prison for 10 years? If the answer is yes, do not do it. If the answer is maybe, do not do it. Do you understand?
Yes, Your Honor.
All right, good luck to you.
Your Honor, we do have victim impact, tip us on the phone.
It's just a statement. she
I'm
sent
just gonna
us.
read it.
Sure.
Okay. I wouldn't even
Okay. All right, could somebody step outside and see if Capmeyer is here on Corley? Douglas Capmeyer, thank you. Okay, they're giving me the paperwork and we'll take that up. No, I don't have, yes, I have that. We're waiting for the attorney.
And then I'll have one more in a few minutes.
Yes. Okay. Tell him we'll have to take him at a break. Oh, sure he can. We'll wait for him to finish, but he'll have to wait on us when we take a break during jury selection. All right, the first person that's going to be up for jury trial is going to be Wardell Lemon. Okay. And then to all the other attorneys who are here for a jury trial, you're going to need to come back tomorrow at 9 a.m. We'll see if this jury trial actually goes. Norma, can I see the files on Alexander Williams? I believe Alfonso Cabanas is in jury trial. Can you check to see if he's? Yes. All right, is he on bond?
Yes.
Okay. Is Carlos Madrigal here? All right, so Norma, just bring that back tomorrow. Alexander Williams, your attorney is in a jury trial in another court. We're just going to make sure that that didn't fall through. Yes, they need to be back here tomorrow at 9 a.m. with their clients. You're welcome. And who has clients that are on bond? All right, if you all can come forward. Everyone who's set for jury trial who has a client that's on bond, please come forward.
Client as well.
Yes. All right, and what is your client's name?
Mr. John Casanova Paez, Judge.
Could I see Casanova Paez, please? All right, you're gonna have to come back tomorrow. We'll see if this jury trial falls through or not. So I'm gonna recall you for tomorrow at 9 a.m. Ms. Ferguson, can you give them a reset form for 9 a.m. tomorrow, please? And I'll need everyone here exactly at 9 a.m. because if we are in jury trial, I'll be able to quickly give you a reset.
Yes, Judge.
Okay.
Richard Thomas, Your Honor.
All right, could I see the files on Richard Thomas? All right, Mr. Thomas, you're going to need to be back here tomorrow at 9 a.m. If we're not in trial, then you will be up. And Ms. Ferguson will give you a reset form. Hi, what's your client's name?
Jesse, you know.
And if I could see the file on Jesse Inaho. All right, Mr. Inaho, we're going to bring you back tomorrow at 9 a.m. At that time, I'll be able to let you know if you are going to trial. If something happens with this trial, you're up. You understand?
Yes.
All right, just get a reset form and then you're excused. Yes.
Judge,
Hi.
y Terrazas.
Okay, could I see the file on Terrazas? All right, we're going to bring you back tomorrow at 9 a.m. Ms. Ferguson will give you a reset form. You're welcome. Thank you. All right, Mr. Capmeyer, are you ready? Bailey Corley. Deputy Mejia, do you have Bailey Corley in the back? Bailey Corley, Corley Bailey.
I didn't bring him back up, Your Honor.
All right, we'll get him here. All right, thank you. Court is calling 2023 CR 4059, State of Texas versus Alvo Tucker. Could I have parties announced for the record for the state? Defense,
Titus for Mr. Tucker?
are you Mr. Tucker?
Yes, ma'am, I am.
Counsel, have you received all, you're in the center, sir.
I'm sorry.
Counsel, have you received all the discovery and did you review it with your client?
Yes, Your Honor.
Court will find that the state is in compliance with discovery. Mr. Tucker, I'm showing you what's entitled application for deferred adjudication. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am, I did.
Showing you the true bill of indictment. Did you review that with your attorney? Did you understand it?
Yes, ma'am.
Counsel, do you waive the reading of the indictment?
We do, Your Honor.
State, are you proceeding on the indictment as presented?
We are, Judge.
Mr. Tucker, I'm showing you what's entitled court admonishments and defendants waivers and affidavit of admonitions. Did you review that document with your attorney?
Yes,
Did you
ma'am.
understand it? And did you sign it in all the appropriate places?
Yes, ma'am.
Did you understand you're charged with burglary of a habitation by force? That's a second-degree felony. Range of punishment is anywhere from 2 to 20 years in prison and up to a $10,000 fine.
Yes, ma'am, I understand.
If you have a plea bargain agreement with the state, the court does not have to follow your plea. If for any reason the court doesn't follow your plea and gives you more than you bargained for, the fact that you entered a plea will not be used against you and you will be allowed to withdraw your plea. Did you understand?
Yes, ma'am.
Did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call and the right to remain silent?
Yes, ma'am.
Did you understand by entering this plea bargain agreement, you were giving up those rights?
Yes, ma'am, I do.
And did you intend to give up those rights and enter into a plea in this case?
Yes, ma'am.
Did you understand if the court were to grant your application for deferred adjudication, if for any reason your deferred adjudication were revoked, the court could find you guilty and sentence you up to 20 years in prison and up to a $10,000 fine?
Yes, ma'am, I understand.
Counsel, has your client been able to provide you with any defenses?
He has.
Do you believe he has a rational as well as a factual understanding of the charges against him?
He does.
Do you believe he's currently competent and was legally sane at the time of the offense?
I do.
Mr. Tucker, has anyone threatened you, coerced you, or placed you in fear to get you to enter this plea?
No, ma'am.
Has anyone promised you anything other than the plea?
No, ma'am.
Are you satisfied with the way you've been represented?
I'm truly satisfied.
Are you a U.S. citizen?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived his right to jury trial. Showing you the plea bargain page. Did you review that with your attorney? Did you understand it?
Yes, ma'am, I did.
According to the plea, there's a $200 fine. State recommends deferred adjudication. There's to be restitution, if any, to the flats at 9338 Paramvital Road. I'm glad you know that.
Yes, ma'am.
78217. Did you understand that to be the plea?
Yes, ma'am.
Defense, is that the plea?
It is, Your Honor.
State, is that the plea?
Yes, Judge.
Showing you the paragraph entitled waiver of appeal paragraph. Did you review that with your attorney? Did you understand it? Did you sign it in both places?
Yes, ma'am.
Did you understand by signing that you're waiving your right to appeal? The only items that can be appealed are written pretrial motions that have been filed, heard, and ruled upon by the court. Did you understand?
Yes, ma'am.
Counsel, are there any such motions?
No, Your Honor.
Outside the agreement, the state is recommending that your deferred adjudication be for a term of 8 years. There be a TAP evaluation, 150 hours of community service restitution, and no contact with 9338 Parent Vital Road or Ruby Moore. Did you understand those are recommendations from the state and the court does not have to follow those recommendations?
Yes, ma'am. I did.
Then to the offenses charged, how do you plead? Guilty, not guilty, or no contest?
No contest, Your Honor.
State any evidence to support the plea?
State overstates Exhibit 1 and attachments.
Any objection?
No objection, Your Honor.
Showing you what's entitled wavering consent to stipulation of testimony and stipulations. Did you review that document with your attorney? Did you understand it? Did you sign it in all the appropriate places?
Yes, ma'am. I did.
Again, did you understand you have a right to jury trial, a right for you or your attorney to cross-examine and confront any witnesses the state would call in the right to remain silent?
Yes, ma'am.
Did you understand that today the state will be presenting evidence in the form of witnesses' statements and police reports? But most importantly, there will be no live testimony. Did you understand?
Yes, ma'am.
Court will find that defendant has knowingly and voluntarily waived and consented to stipulation of testimony and stipulations. Court will accept into evidence states exhibits 1 and attachments and review the same. After reviewing states exhibits 1 and attachments, the court will find there is sufficient evidence to find you guilty. Court will defer finding of guilt as you've applied for deferred adjudication. Are we proceeding with sentencing?
Yes, Your Honor.
Anything you wish to say on behalf of your client?
Just that he understands what's happened and he's eager to try and complete everything on his to-do list. And he would like to apply for early termination.
All right. Why are you squatting in an apartment that doesn't belong to you?
I wasn't squatting, ma'am.
Well, how do you know this person?
Because my girlfriend lives in the apartment. I stayed there. I stayed on the residence.
You stay where?
I stayed there at those apartments. Well, stayed there. I recently just moved
Stayed there with who?
with my Alexis,
And who is Alexis?
my fiance.
So she's gone from girlfriend to fiance.
Well, yeah, we was in the works in the process.
When's the last time you had a job?
Well, I came here.
And when was that?
February the 13th. I got here February the 16th.
Doing what?
I was a project manager for a roofing company.
Mhm.
Champion Roofing Construction.
Do you have any drug issues?
No, ma'am.
Does your fiance have any children?
No, ma'am.
Do you
No.
have any children? I'm
No.
sorry, what?
Not here. She has older children, but not.
Are they adults?
Yes, ma'am.
Do you have any children?
No, ma'am.
Where's your family?
I really don't have any family, ma'am. My father passed. I don't know my mother.
Why don't you know your mother?
She gave me away to my grandma when I was real young and never really just got to really know her. I know of her.
Mhm.
And I know she's doing good for herself. And I've talked to her on several occasions.
And where's your grandmother?
She passed.
And what are these tattoos about?
This loyalty, peace, and honor. I got them because I got stabbed years back and almost cost me my life. And that's just my last name, being a kid. First
How old were
tattoo.
you when you got that?
I was about 15.
Who gave you a tattoo at 15?
My cousin thought he was a tattoo artist.
Okay,
He really isn't. It's horrible.
all right. 8 years deferred adjudication, there's a $200 fine that will be probated. Restitution, if any, and no contact with Ruby Marie Mora and the flats at 9338 Parent Vital Road. That's San Antonio, Texas, 78217.
Yes, ma'am.
150 hours of community service restitution. proof of employment
I can get that to you.
within 45 days of release. There's to be no employment as a home health care provider or with minors. Random and regular UAs. Regular reporting by Zoom or in person. Field visits one time per month for 3 months. And those are to be random. And if there are no issues, then probation, you can discontinue the field visits. Is there anything else he needs?
No, Your Honor.
Is there anything else you need from the court to be successful?
No, ma'am, I appreciate it.
Showing you what's entitled Trial Court Certification of Defendant's Rights to Appeal. Did you review that with your attorney? Did you understand it? And did you sign it?
Yes, ma'am, I do.
All right, because this is a plea bargaining agreement, because I followed your plea bargaining agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Do you understand?
Yes, ma'am, I do.
All right, good luck to you. Do better.
Yes, ma'am, definitely. Thank you, Your Honor.
You're welcome. Okay, all right. Oh, no problem. Are you able to come tomorrow?
Because the 262, if we start right at 9, and if I can get out of here by 9:25, I'll find a
Yes,
hole.
if you're here exactly at 9, we'll take care of it. All right, so Norman, we call that for 9, and we already have all the paperwork. And
Judge,
you're welcome.
see you then.
All right.
Judge, may I approach?
Yes.
And then rejection. And then rejection, sorry.
Oh, no problem.
See them faster. And Judge, I think that was it for us, but we'll be here tomorrow to help with that.
All right, thank you.
Thank you, Judge.
All right, and then. Yes. Those are coming back tomorrow. Norma, on Alexander Williams, just put him for tomorrow, and then we'll talk with Alfonso Cabanas and see when they can come back.
Yeah, he's in trial.
Okay.
And I can text, well, I can text him tonight. just-
Yes. Okay.
I can talk to him tonight if you want me, I can text you.
Well, the reason why I want it back is so his client will know. But you can text him and find out with the state what's a good date, but still bring Mr. Williams back and we'll tell him what date his case has been reset for and why. So just make sure Mr. Williams is brought back tomorrow. All right, I need to see the file on Wardell Lemon. Counsel on Wardell Lemon,
Yes, Your Honor.
has he done an election
He has.
and
The jury.
to the jury?
Everybody see tomorrow.
All right, bye-bye.
Filed back in January.
And Your Honor, this has so many settings, I'm sure that usually discovery law. Trying to check on that. What's the, listing? I'll go ahead and generate one. Yeah,
It's an HDMI, right, on this one. I don't know if you, I know that it does work if you have an HDMI cable. Or not. I have an HDMI.
I'll rent you mine.
You may have it. Oh, I see.
So I can choose the computer.
You don't have an adapter?
Okay.
Okay.
Usually it's just fixing.
The jury things are on the. Yes, for the stance of performance and returns, which is in the meeting.
Sure.
The smallness. All right, we're going to go on the record. Court is calling 2020 CR 7353, State of Texas versus Wardell Lemon. Can I have parties announced for the record for the state?
Brittany Mitchell and Ruben Herrera.
Defense?
Diego Gonzalez and Mario Moreno for defense.
All right, and are you Mr. Lemon?
Yes.
All right, it's the court's understanding that the charge is indecency with child by contact. Is that correct?
Yes.
That's correct, Your Honor.
And defense, you received all the discovery?
Yeah, Your Honor.
All right, the court will find that the state is in compliance with discovery. Did you review the discovery with your client?
Yes, Your Honor, we have received.
And it's the court's understanding that if Mr. Lemon were found guilty, then he would be going to the jury for punishment. Is that correct?
That is correct, Your Honor.
All right, each side will have 30 minutes.
Do you have that for me?
And defense, I'm not sure if you've been in jury trial with us
Have
before.
not, Your Honor.
The way we handle strikes is you just question them, but I don't have you strike them in front of the panel because I think that may cause issues.
Right.
And then once everybody has finished their voir dire, then you all can see what you can agree on.
Okay.
But I don't do general and specific. You just have your set time and that's that. So each side has 30 minutes.
Okay.
Do you all want a time announcement?
Yes, Your Honor, if I could have a 5-minute.
Same, Your Honor.
Judge, and I really believe the state will finish our case tomorrow. But if in the event we go further, I'm gonna qualify Travis. Because I'm going to-
All right.
Yes.
All right, defense. The state believes that their case will be finished tomorrow. State, are you anticipating finishing it before noon?
No, I think it may be the afternoon.
All right, so just to be on the safe side, defense, if you can have your witnesses here, you're going to call witnesses. If you can have them here by 2 p.m.
Okay.
Oh, sorry. And please use the mics so the court reporter can hear you.
What did?
I do.
Very fan. Yeah, I just said, I did plug it in.
Thank you, sir.
I just- So what I'm trying to do-
I think that would be great. We do already have a Festivus.
We need one.
Oh, you mean a new Festivus? We haven't done a new Festivus, but that is coming. Who knows? Maybe we'll be able to do it the first week in July or the second week in July. We'll see. I think the first week in July is going to be,
I'll show you how I.
we could,
It switches.
but here's the problem. The problem is July 4th is on a Tuesday. So I don't think it's right for people to come in on the Monday and then leave on the Tuesday. So we're off Monday and Tuesday for the July 4th, and then we're gonna have a heavy schedule, July 5th and 6th. And then I'm gonna be gone next week to see mom. Of next week? This week, okay.
And they did send out the other day, so that we could run our normal laptop and do an HDMI. Is it like an HDMI?
Yeah.
Yeah, so that HDMI
All right. Oh, okay.
Is there an HDMI?
Yes. All right, is everyone's equipment working?
We're not getting it to come up yet. Which nobody's. is.
There's a problem. Well, the AC isn't working.
Oh, Judge, the AC, I found out that something actually broke wherever the AC is at.
Mhm.
So they're waiting for some repairmen contracted to come in.
Oh, there goes.
I was gonna say, I was here.
Doesn't
on
matter.
Saturday.
I think sometimes it takes a while to
Mhm.
load up. Try hit promising.
Okay, so it's working.
Working.
Yes,
All
the
right.
magic
Hit it down
just
button.
worked. I don't.
See?
Oh, does
None
Leo
of
have the
this makes
same
sense.
fancy one?
No, I have my own.
I know, but it's
Similar.
another
Similar,
fancy
yeah.
one.
Elongate.
What paperwork
There
is
you go.
this?
But it's
Like
not,
it's got a.
Oh, but it's
pen
not-
clicker's
button.
not working.
Who's
You know, maybe after we take out the other clicker,
If
or
you
maybe
wanna-
it's working the front.
Yeah, we can just use our
What is your
clicker.
judge ready?
Yes, are you all ready to proceed? We're gonna bring the jury in. All right, let's bring them in.
With that up there?
It's a little back.
Thank you.
You can just.
Do y'all wanna, excuse
Did you
me,
confirm mine? is
state?
working?
Not
State.
yet.
I
Oh,
didn't say
If you all wanna take that down.
oh, yeah. We
Okay.
can, just, put up a black
Wait,
screen.
yeah, that's right. Yes.
Ready?
All right, we're ready.
Think so, Judge.
Ready, Mejia?
Oh, here it is. Here it is. Yeah, it is. Okay, good luck.
Awesome, just.
Can we take, I don't know.
Oh,
okay,
So
okay.
we'll switch it when.
Okay.
Number one. One. First row and the bottom. First row, all the way. Number eight. Eight, second row on top. Have a seat. 50. 50 on the first bench.
Yes, it's kind
Oh.
I don't know how.
Meet your numbers. You're the meet your numbers.
All right, everyone, please be seated. Good afternoon, everyone. All right, that's a delay. Good afternoon, everyone. Oh, that is so much better. I am Judge Stephanie Boyd. You're in the 187 District Court on the 4th floor. So where are you? And who's the judge?
Stephanie Boyd.
You know, you're all the first jury that we've had that didn't trail off when it got to the name part. The reason why I always do that is because whenever we have a break, all of you have to leave the courtroom so nobody can stay behind. And we've had some people get lost because these buildings are very confusing if you're not here on a daily basis. So if we have a break, and if you look up and all the jurors have left you and you're lost, if you remember 187th District Court, or if you remember Judge Boyd, someone will be able to point you right back here because I'm the only Judge Boyd in the courthouse. Now, let's address the elephant in the room. It's extremely hot. And this courtroom had trouble with the AC. Then we got the AC fixed. And then someone who we say was a guest in our home told somebody, it's too cold. And the AC got changed. But now the issue with the AC, Deputy Laura has informed me that there is a part that's broken. And everybody in all this building are hot. So think cool thoughts. Maybe that will work. So we do have this door open. And the reason why it's open is to help a little bit with the circulation. Now, if people would have thought about having ceiling fans in here, we would be in better shape, but they thought these would be better decorations. I had no say so in that. So you may use the expensive cards you have as fans. And if everyone could hold those up, if you could, all the cards. I'm going to try something. And what I'm about to try, no jury, and we have a jury trial every week, has ever been able to follow this. So I'm going to see if you all can do it. So everyone hold up your cards. Now, if you're in this box, lower your cards. You can lower them. If you're on this front row here, lower your cards. Anyone else, if you are holding up your card, whenever you speak, I'm going to ask that you please stand if you can. Does everybody understand? Are you all going to be the first jury that's able to follow through on that rule?
Yes, ma'am.
Okay, see, somebody is very enthusiastic about that. They're going to make that happen. The rest were a little bit shaky. The reason why I do that is to my left is the court reporter. Diana, can you raise your hand? It is very hot, so I'm trying to make her job as easy as possible. She takes down everything that everyone is saying. And when you think about that, that's a difficult job because people speak at different speeds. Some people mumble. So to make her job easier, because the acoustics are not great in the back, please stand when you are answering a question or if you have a question that needs to be asked. And anytime you have something you need to say, just raise your card and someone will call on you. Does everyone understand?
Yes.
All right. Now I'm going to have the state, if you'll introduce yourself, please.
Yes, good afternoon. My name is Brittany Mitchell. This is.
I'm Ruben Herrera. Travis Banks.
All right. And this is the state of Texas versus Wardell Lemon. Defense, if you could introduce yourself, please.
Good afternoon, ladies and gentlemen. I am Leo Gonzalez.
And I'm Mario Moreno.
This is our client, Wardell Lemon.
All right. All right. You've had a chance to look at those parties. Does anyone recognize any of the parties who just introduced themselves to you? All right. I'm going to take that as a no. Now, the charge in this case is indecency with a child by contact. And I know sometimes people are saying, why couldn't I get to be called up for jury for a car accident? But in order to have jury trials, guess what the number one thing is that we need? Thank you. Right? And so I understand that sometimes people may feel as though cases are difficult, but in all jury trials, what people really want to know is whether or not you can base your decision, if you're able to come to a decision, if you can base it upon what you hear in the courtroom. Does everyone understand?
Yes.
Now, the other people I want you to take note of is the two people who are over here. These are two young people who have decided to enter maybe the legal field. So they are just observing. So they are not a part of this trial per se. They're just here to see if this is a profession they wish to be in. Now, I want to talk to you about this case. It's going to be hypotheticals. So what does that mean? The state and the defense are not to speak to you about what they think the facts are in this case. They're only to talk to you about hypotheticals. So remember, when the state is speaking to you or the defense is speaking to you, they're not talking about this specific case or the facts in this case. Does everyone understand?
Yes.
The only way you'll hear about what people think the facts are in this case is if you are on the jury panel. Now, the way a case comes to felony court and on the criminal side is by way of an indictment. Has everyone heard of the word indictment before?
Yes.
Okay. So with an indictment, it's just to tell a person what they're being charged with, where they need to be, and when they need to be there. It is not to be considered by you as evidence whatsoever. Does everyone understand?
Yes.
For example, and raise your cards. How many people have had a traffic ticket? All right, we have some horrible drivers in here, but that's okay. There's one person in the striped shirt. You've never had a traffic ticket? Yes.
No, I just started driving in October.
All right, so she doesn't have the experience yet, so okay. Well, for example, if an officer were to pull you over and say that you ran a red light and they give you a ticket. I've had one ticket in my lifetime and they wrote on a piece of paper and they handed me the ticket. Now I think they do some kind of electronic way. When they give you that ticket and you show up to municipal court, you're receiving that ticket is not you saying, oh yeah, I ran the red light. That ticket is just mainly to tell you what the officer is accusing you of and where you need to be to answer to that. Does everyone understand?
Yes, sir.
Yes.
All right. Is there anyone here who's going to hold it against Mr. Lemon because he's under indictment?
No.
Now, there are certain rights that everyone has if they're charged with a criminal offense. One is the right to remain silent. Has everyone heard of that before?
Yes.
All right. Where are my Beretta and Mannix people? Thank you. See, other people are pretending like they're not in that age bracket. I know they are. So for some people, it's maybe paper chase, the practice. Well, what that means is that anyone who's charged with a criminal offense, they do not have to testify. They have a right to remain silent. Now, there are many reasons why somebody would decide not to testify. I've been a prosecutor and I've been a defense attorney. Sometimes when I would represent a client, I would tell them, you don't need to testify. The state didn't prove their case. Or sometimes you have a client who's extremely shy or afraid. They're afraid of public speaking. So there are many reasons why somebody would choose not to testify. And if they were to choose not to testify, you can't hold it against them. You can't be Mrs. Kravitz on Bewitched, wondering, oh, I wonder what they would have said. What? You cannot do that whatsoever. So if Mr. Lemon were to decide not to testify, you can't consider it. You can't hold it against him. Is there anyone here who would hold it against him if he decided not to testify?
No.
The next thing I want to talk to you about is the burden of proof. Everyone who's charged with an offense is presumed to be innocent. When the officer gives you your traffic ticket, you're presumed to be innocent of that. And so in criminal cases, you're presumed to be innocent unless and until the state proves its case beyond a reasonable doubt. And that means proves every element. So what does that mean? What is proof beyond a reasonable doubt? There used to be a definition for proof beyond a reasonable doubt. When I graduated from law school, everyone needed to know that definition. If you didn't know that definition, basically you were a failure. I knew that definition forwards and backwards. I knew where the comma was. I knew where the semicolon is. I knew where the pause. Had that in my first trial. Second trial I have, there is no longer a definition of proof beyond a reasonable doubt. So as a prosecutor and a defense attorney, I would tell people what it wasn't. So for example, on the civil side, they have two burdens of proof over there. One is preponderance of the evidence, which is more likely than not something happened. So if you're deliberating on a jury in a criminal offense and you're deliberating, you're saying, well, I think more likely than not that happened, you know that you are not at the correct burden, because more likely than not is for the civil side, not the criminal side. The other burden on the civil side is what's called clear and convincing evidence. Clear and convincing evidence is the type of evidence that's needed when the government is trying to terminate your parental rights. So they're saying you're a bad parent, you'll be a danger to this child, so we're going to take away your legal right to be their parent. That burden is not the highest burden that we have. The highest burden that we have is proof beyond a reasonable doubt. Does everyone understand? So in this case, the state has approved each and every element beyond a reasonable doubt. Now, there are two phases to a jury trial. The first phase, some people call it the innocence phase, but that's not really what the first phase is. The first phase is what is not guilty or guilty phase. Did the state prove their case? Did they not prove the case? That's phase one. If you decide that someone is not guilty, the trial is over with. If you decide that someone is guilty, you go to the second phase. And the second phase is what is called punishment, where you decide whether someone should go to prison or not go to prison. Does everyone understand?
Yes, yes.
Okay. According to our law, anyone who's going to a criminal trial, they must make an election or a selection to say, if I'm found guilty, who would I like to determine my punishment? It's the law. They have to do it. By doing that, the person is not saying they're guilty. They're just saying, if I'm found guilty, either I want to go to the judge for punishment or either I want to go to the jury for punishment. Does everyone understand?
Yes.
In this case, Mr. Lemon has decided that if he were to be found guilty, he would go to the jury for punishment. Is there anyone who's going to hold that against him? Okay. The range of punishment in this case is anywhere from 2 to 20 years in prison and up to a $10,000 fine. Now, that's a wide range. I think everybody will agree with me. It's 2, 3, 4, 5, 6, 7, 8, 9, 10, all the way up to 20 years. Does everyone understand?
Yes.
Nobody ever really concentrates on the $10,000 fine because honestly, nobody knows where the $10,000 fine would go if someone were to be found guilty. So usually the concentration is just really on the 2 to 20. Because you don't know anything about a case, it's hard to say what you would give someone if they were found guilty. Does everyone agree with that?
Yes.
Usually what people want to know, they say, well, I need to know some facts before I can make a decision on whether or not I would sentence somebody to 2 years all the way up to 20 years. Well, the way the criminal law works is you don't know any facts about the case, but in your head, you have to be able to consider the full range of punishment. For example, sometimes in sex cases, you don't know the age of the people. Maybe the age of the people is 16, 21. And maybe that's something you would be able to consider on the lesser end for somebody. If maybe you knew they were dating, the parents approved of it. You understand? So think of different scenarios. Is there anyone here who would not be able to consider the full range of punishment?
No.
Okay. State, could I see state and defense for one moment, please? All right. The next thing I want to talk to you about is punishment. Is there anyone who, for religious reasons, cannot sit in punishment of someone else? Okay. Now, I'm going to talk to you about something that's called the one witness rule. Do not, I repeat, do not add any facts to what I'm about to give you. Consider these facts as the facts. Someone comes into court, I swear them in. They swear that they're going to tell the truth. They come in, there's no issue with their credibility. They don't wear eyeglasses. There was no problem with their vision. There is, well, maybe not. Maybe they were not, maybe they didn't remember it correctly. There's nothing wrong with their memory. This person is credible. You believe they are telling the truth. Does everyone have that fact scenario in their head?
Yes.
Now, while you hold that in your head, I'm going to ask you this question. If someone were robbed, right? And there are only two people, the person who was robbed and the person who robbed them. How many of you think that that case should just be let go because, hey, it's only two people? Is there anyone who feels as though the person in that scenario who was robbed, people should just turn them away and say, you know what? Sorry, it's just you and the person who robbed you. So we're going to not do anything with that case. Is there anyone who feels that way? All right. So let's go back to my fact scenario. So you have someone who is charged with an offense. And again, we're speaking in hypotheticals. That person comes in to testify. They're sworn in. They say, I swear I will tell the truth, so help me God. They testify. There is no issue with their credibility. You believe them, and that person proves the state's case. They tick off every box. And this is the point where I do this scenario where people say, well, is there going to be something else? No, it's the one person testifying and you believe them. Is there anyone who would not be able to find someone guilty if one person comes in to testify, you don't have an issue with their credibility, and they prove the state's case, every element? So they prove it happened on this day. They prove it happened in Bexar County. They prove everything that the state needs to prove. Is there anyone who would not be able to find someone guilty under that fact scenario?
No.
All right, the next thing I want to talk to you about is the English language. I love languages. I'm originally from Louisiana, so guess what extra language I took other than English? Thank you. Thank you. So that's where I'm supposed to be right now. I'm supposed to be retired at 21, living my life up in France. Here I am, 22 years old, not retired. Okay, there shouldn't be that much laughter for that. So when I went to undergrad, grad school, and law school, I was surrounded by people who spoke different languages. Basically, I know how to say hurry up in almost every language. That's the only thing that I retained other than French. So is there anyone here whose English is not your first language? Raise your card. Don't be shy. So number 8. And as I call your number, lower your card. 16, 26, 29, 34. Thank you. All right, number 30. 30.
There's a couple on this side.
All right, thank you. 71 and 74. All right, juror number 8, what's your first language? Oh, this is new. We haven't had Korean here yet. So how do you spell hurry? How do you say hurry up in Korean? Thank you. I need to know where you've been. All right. Have you been able to understand everything? Okay. How long have you been in the United States? All right. Thank you. Number 16. Yes. What's your first language?
Wow.
Yes, I've had Farsi before, but tell us how to say hurry up in Farsi. All right. Did you get that down? All right. Have you been able to understand everything? Thank you. Number 26.
What's the question? I'm sorry.
All right. What's your first language?
Spanish.
All right. See, you all are not standing and you all didn't help him out.
Spanish. I know Spanish.
All right. So have you been able to understand everything?
Yes.
And how do you say hurry up in Spanish? Yes. Thank you. All right. Number 29.
Spanish.
All right. Have you been able to understand everything?
Yes.
Did he say hurry up in Spanish properly?
Yes.
All right. Thank you. I'm waiting for somebody to say no, and we'll see what happened. Number 30. And what's your language?
Tamil.
Oh, how do you spell that?
It's an Indian language, Tamil. I'm from India.
Oh, how do you spell that? What you said?
TAMIL. REISM.
And how do you say hurry up in that language? All right, I got that. So have you been able to understand everything? All right, thank you. Number 34. What's your language?
Spanish.
Spanish. Have you been able to understand everything?
Yes.
Did they tell me how to say hurry up in Spanish appropriately?
Yes.
All right, thank you. Number 71. Okay, that's new. How do you say hurry up in Japanese? I'm gonna work on that one too. So have you been able to understand everything? All right. When you say most of it, how much? Okay. All right. Thank you. Number 74. Where is 74? Oh, what language? Where is that from? Oh, what? Okay, this is new. How do you say hurry up? Oh, so have you been able to understand everything? We've had some new people now. I like that. I love the language. All right. Is there anyone here who has any time constraints or travel arrangements where you cannot place the ticket in my name? All right. So raise your cards. Oh, he put his down like he can put it in my name. Number 3, 6. Okay. 3, 5, 6, 14, 16, 40, 56, and 63. All right. You can lower your card. Number 3, what's your time constraint?
I'm leaving Thursday morning,
Where are you headed?
Colorado, meet my grandson,
How old is your grandson?
5 weeks.
Ah. Is he named after you?
Yes.
Ah, did you have a hand in that or did they just automatically say?
It's a surprise, actually.
Oh, okay. Number 5,
When you mean time constraints, you mean like going out of town or like I have to pick up my kids? from-
going out of town, picking up children.
You have to be like their daycare summer program closes at 6:30.
Okay, and what time is it?
What time?
What time are you responsible for them? I know you're responsible
Oh.
all the time, but what time frame?
I have them and I have them all the time. They're 24/7.
Okay, what are their ages?
There are. Well, okay, I have 4 kids, but those one doesn't count. He's an adult. Sorry.
Okay.
So 14, 8, and 6.
All right, and who's with them now?
They are with their grandmother.
Okay.
Because they're at swimming lessons.
All right, are you afraid the grandmother's going to spoil them?
No.
All right, number 6.
Yeah, a couple of things, Your Honor. we watch our grandkids on Tuesdays and Thursdays. They're 2 years old and 4 years old.
Okay.
So it's my wife and I, so she's hopefully with them right now. And I've got doctor's appointments on next Monday and next Thursday.
All right. I don't know what's going on in Texas where people are not having their 2 and 4 and 6-year-old driving yet. I just want to- So is that are you taking care of her grandchildren? Are you guys? All right, number 14.
I'm going to Nashville on Sunday.
Oh, what are you doing in Nashville?
My 16-year-old has a baseball tournament.
Oh, wow. I know a couple of people who have baseball tournaments in Nashville. All right, number 16.
Mine is for next week. I'm going to Houston and Hawaii.
Oh,
I don't know how long.
all right. What are you doing in Hawaii? Nobody cares about Houston.
Everything everybody else is doing.
Okay. All right, number 40.
Going to Dallas, next Friday. To see my grandparents and.
Okay. All right, are you going to stop by South Fork? You even know what South Fork is?
Not sure what that is.
Oh my gosh, we're so old. All right, thank you. Number 56. All right, and what is, if you don't mind me asking, what is the test for? All right, and what are you on probation for? All right, thank you. And you say that's Friday? Tomorrow at 9 a.m.? All right, thank you. Number 63.
I'm attending a professional development conference in Washington, D.C., and I leave on Sunday.
All right, professional development, what is that?
Arts integration and instruction for classroom teachers.
Oh, all right, thank you. All right, number 60.
Yeah, I'm going to Dallas on the 30th of June.
All right, thank you. Usually once people see that nobody is struck by lightning, then everybody's card starts going up. All right, so you all have had number 15.
My son has his 1-year-old checkup on Friday and he's having shots. So
All right, you have to be there for shots so he'll know who's responsible. All right, anyone else? 25.
My shifts are graveyards. It's kind of hard to get down here. I work all night.
Okay, all right, thank you. Number 1. Oh, come on, people. You have to be brave. All right, number 1. Okay, thank you. 28.
I have a 14 and a 9-year-old. I don't have anybody to watch them. It's just us.
So they're at home now by themselves?
Yeah, the 14-year-old babysitting. Dear God, I hope the little one's not dead.
Okay, all right, thank you. Number 32.
I work the graveyard shift from 7 to 7, and I do a lot of driving, about 300 miles a night. I work roadside assistance.
Okay, all right, thank you. Who else? 42.
I had surgery in the recruit part of my house. And I'm going to physical therapy over till end of July. Got to go every Tuesday and Thursday. I'm improving, but I'm still having pain.
All right, thank you. Who else? 45.
I work the graveyard from 10 to 8 in the morning, 6 days a week. And I'm the only one in my house who has an income.
All right, thank you. Number 55.
This Thursday, I'm leaving to Apostle. I'll be back to maybe Monday or Tuesday.
What are you doing in El Paso?
Bringing my dad down. He felt very ill, so I'm gonna bring him towards so he can live with us.
All right, thank you. 54.
I don't know how far off the vacation should have been, but flights July the 4th going to Washington.
I don't think we're going to be here July 4th, but thank you for letting us know. Sometimes people just want to make everybody jealous about where they're going. Number 59,
I had a job interview tomorrow.
for who?
Best Buy.
I'm sorry,
It's at Best Buy. It's a job.
Best Buy. All right, thank you. 75,
I'm a clinical dental hygienist and I have this patients.
all right, so everybody, remember, you've got to speak up because the court reporter can't hear. All right, anyone else? All right, so you all have had a chance to see each other a little bit. Is there anyone who recognizes anyone on the panel other than just having met each other downstairs or in the hallway? That's odd. Usually there's a teacher and a student or coworkers or something. I see somebody who's thinking they may know somebody, but they're not going to raise their hand. Okay. All right, so I'm going to tell you all two stories. They're both true. I know that jury duty is an inconvenience, and I say it's an inconvenience. It's not a sacrifice, it's an inconvenience because there are a lot of one-ways. When you're driving downtown, and if it's the first time you're driving downtown, you maybe want to make a left or right, and you're like, the building is right there. If I could make this turn, I would be right there. And then that makes you start thinking about the gasoline. Then if you're able to find parking, you find parking, and parking is expensive. So these are inconveniences. But your government doesn't really ask a lot of you. The only thing the government asks of you is to pay your taxes and to serve on a jury. That's it. And the reason why I say it's an inconvenience is because my uncle grew up in Grand Cane, Louisiana, small town, super intelligent. He's since passed, but he was super, super intelligent. And he had sisters and a brother. And all of the teachers would skip him to the next grade because he already knew everything. And of course, when his sisters and brother came after him, all of the teachers knew all of them and knew all of their students. So they would always tell them, we're expecting a lot out of you because your brother's super smart. So Vietnam War breaks out. He's graduated from high school, but he's graduated early because he was skipped through school. Tells my grandmother, I'm just going to go ahead and sign up because they're drafting all of the boys here in Grand Cane anyway. So my grandmother had to sign for him to go off to war. And at that time, people will tell you, nobody knew where Vietnam was. They're like, where is this? What's going on? And if you can think back to that time frame, there was no email, there was no cell phone. My mother still remembers their telephone number because it was 4 numbers and you had to pick up the phone and call the operator to have them connect you. So my grandmother signed for him to go off to Vietnam, not knowing whether he was going to come back or not being able to pick up the phone and call him immediately. Did you make it safely to your destination? Sending him off to boot camp to who knows where. And he's just a country boy born in Grand Cane, Louisiana. So I tell everyone, that's a sacrifice. Jury duty is an inconvenience. And all your country is asking for you now, unless somebody changes the law and starts the draft, all they're asking for you is to pay your taxes and serve on a jury. So I realize that it's an inconvenience, but this is what your country is asking of you. So they're not asking you to make a sacrifice. The other thing I want to tell you about is one of my friends from law school. She decided to do civil law. I always wanted to do criminal law. Usually on the civil side, you're not in court every day. On the criminal side, you're in court every day, usually. And you have a lot of trials, usually. So we hadn't seen each other for a while because she's doing civil. And on the civil side, you usually have billable hours. So you're there late. And I'm on the criminal side. She calls me and says that she has jury duty. Could we do lunch? I tell her yes. And we meet for lunch and I ask her, how is jury selection going? And she says, it is going fabulous. Well, since I've been a judge, now I look back on it, how can it be fabulous? You're not in the 187th with Judge Boyd, so how is this fabulous? And so she tells me, I'm not going to be on the jury because it's like law school. I'm in the back. I'm not saying anything. I'm keeping my head down. I start laughing. She says, what's funny? I said, it's a good thing. She's like, what's the good thing? And I tell her, we're going to have lunch all week because you're going to be on the jury. So other than remaining completely silent, the best way to end up on the panel is for you to hold up a card and say, please select me. And I tell everybody that story is because both the state and the defense have this small opportunity to get a chance to know you and make sure that the people who are on the jury are people who will listen to the evidence that's presented to them and make a decision on whether someone is guilty or not guilty based upon the evidence that they hear. Does everyone understand? All right. Does anyone need a break before I turn it over to the state? Number two? All right. So ladies and gentlemen, as I said before, when one person leaves, you all have to leave. So make sure you leave your numbers behind. I'm going to have us come back at 3:05. Now, if you need to take a restroom break, I know that sometimes the restrooms are crowded. Wherever you see a stairwell, as long as you follow that stairwell up and down, there's a restroom on either side of those stairwells. So down at the end of the hall, restrooms on either side. So whatever floor you go on. So everyone, we will be back here at 3:05. Look to your left. Look to your right. You're responsible for that person being in line. All right, everyone, please rise. Is it working?
Okay.
Oh, you have to make sure that they clipped it on over there. Oh, it is hot. If I would have known you all would anticipating resting tomorrow, then I would have said, let's pick the jury in the morning. But that's okay. Did you click?
It's on over here.
Right for the jury?
No, it's not.
Did y'all click it over there?
These ladies and gentlemen.
Deputy Laura, can you click that on for them? Thank you. Did y'all click the button
Yeah,
on your
it's on.
table? All right. Are you all ready to proceed then?
Yes, Your Honor.
All right. State, you may proceed.
Thanks. Good afternoon. It is hot. I know y'all are tired. Jury duty is not fun to begin with, and when it's this hot, it's very painful, and I understand that, so I'm gonna try to go as quickly as I can. My name is Brittany Mitchell. We introduce yourself, but there's Ruben and Travis. They are my partners. This is a case of indecency with a child by contact. We work in the Family Violence and Sex Crimes Division. So we handle these cases almost exclusively, as well as domestic assaults. One thing, it went away again. That's okay. So y'all can kind of see it. I have a picture of Law and Order people. Did anybody here watch Law and Order? All right, cool. Can anyone here say the names of the, not SVU, but the names of the old school Law and Order people? Let's see. No, anyone? Sure, I saw somebody nod their head.
Any of the characters?
Any of the characters, yeah.
First, Chris and Dora.
All right, well, so I put that up there to kind of separate myself. This is not TV. We do not have all the fancy technology, as you can tell, that they have. We don't have, you know, our hair and makeup don't look awesome every day. And the reality is that we are constantly moving. We're constantly going through cases. And so I say that all just to kind of let y'all know, you'll see us on our phones, doing things, texting people. It is work related. I just have to get that out because sometimes it looks like we're not in our cases, but it is us just coordinating the next trial. We were in trial last week, we're gonna be in trial coming up. So I don't know why I'm even doing this. My next slide is a picture. I usually ask, hey, who knows this picture? But y'all don't see it. Anyone over here who can glance at the screen and tell me what picture this is?
12 Angry Men.
12 Angry Men. 12 Angry Men. All right. Does anyone in the big audience know what 12 Angry Men is? Let's see, juror number 69. Stand up.
Because basically it's like a jury, like they're working through a case.
Yeah, it's kind of a good example.
I believe it was also hot in the movie as well.
Yeah, so it's a really good movie to kind of show the power of being on a jury and kind of what can happen if you get selected. It's just so frustrating. So there are a few ground rules with jury duty. At this point, you know, the only oath that you have taken at this point is to tell the truth. It is a safe space in the way that I need to hear from you. You know, there are cases that are just not suited for some people. Another thing, understand the splash zone. Does anyone here, we're in San Antonio, but does anyone here not know what the splash zone is at SeaWorld? Anyone? Anyone who doesn't know what that is? Yeah, but there you go. That's fine. That's fine. Juror number 12. Anyone want to tell juror number 12?
Get wet.
You get wet, right? So when they have, you know, the shows with the whales or the dolphins, there's a section usually always right by the pool area, and it's called the splash zone. The seats are a darker color, and it's kind of a warning like, hey, if you sit here, you're probably going to get wet. There is a splash zone. Unfortunately, you're not going to get wet. You're not going to cool off with water, but the splash zone for jury purposes, I usually think is the first 30 or so. And so jurors 75 and over there, if you don't, I may not center on you as much, but if you're in the splash zone, just be aware that if you don't speak, a high probability you'll get on the jury. Okay. And then from the Office of Court Administration, I pulled this quote: jury service is a privilege that offers the average citizen an unequaled opportunity to influence and deliberate over fundamental matters of justice. As a juror, you are in a position of responsibility. You will need to be fair, impartial, and be willing to make decisions that are not based on your personal feelings and biases. So that's what we're here today to talk about, is who here can be fair and impartial. I noticed somewhere there's a Circle K manager. Juror number 28. So I'm gonna bet if our case is say an armed robbery of some Circle K convenience stores, that may not be the best case here. Yeah, because it happens. And so that's kind of what we're looking for, people who maybe have experience with this, or for some reason or other just cannot put that aside and listen to the facts and the evidence and render a verdict according to the law. Okay. I also, on this PowerPoint that no one can see, I have a picture of Cheech and Chong, and what are Cheech and Chong known for? Smoking. So they might not be the best on a possession of marijuana. Okay. And that's fine. They'd probably be great on any other kind of case, but not that one. Indecency with a child by contact. I told you we're in the division where we handle sex crimes, and so it's very common. People come in, and as soon as they hear the charge, you can kind of hear an audible like, oh, you know. And so I want to make y'all understand that that's okay. You know, it's okay to hear that offense and like kind of like, ugh, you know, because it's against the law, right? If we were okay with it, it wouldn't be against the law. So the important thing is to understand there's the offense, but someone's being accused of it, right? It doesn't mean just because there's an offense and you find that offense personally repulsive that you can't be a good juror. Okay. There are elements, as an attorney, you know, we follow the law, and the law has certain things that have to be met to find somebody guilty. And it's kind of like bullet points that we have to prove in our case. And that is on or about a date, the defendant, Wardell Lemon, intentionally or knowingly engaged in sexual contact, which is touching of the genitals, anus, or the female breast, and can be under or over the clothes of a child younger than 17 years of age. Okay. With the intent to arouse or gratify sexual desire. Okay, so, you know, bathing a kid, it's fine, right? It's when that sexual desire comes in. What's not in here are, you know, what clothes they were wearing. What's the motive for this? Well, other than sexual desire, that's a bad word. But these are the elements we have to prove, and I really wish you could see them, but you'll hear the law if you get on the jury when the judge reads it to you. Intentionally or knowingly is what we call the mental state. A person acts intentionally if it's their conscious objective to cause the results, right? I'm intentionally hitting Ruben on the head. A person acts knowingly when he's aware that the conduct is reasonably certain to cause the result. I may not intentionally mean to hit Ruben on the head, but if I'm swinging my arms around, I know that that's a reasonable result, okay? Okay, when we're talking about children, and in this case, it's ages 0 to 16, because it's younger than 17. There are certain considerations. Let's see. I like to use the example of bullying. Who here has had a child who has been bullied in school? Okay, so if you'll raise your cards. 3, 5, 6, 7, 10, 11, 15, 16, 17, 19, 28, 33, 34, 35, 36, 39, 42, 45, 53, 54, 55, 61, 63, and I can't tell your number. 67. Okay. Yes. Yeah. Now, let me see. Juror number 7. When did you find out about the bullying?
It was a student that came to me.
Okay. Oh, the student came to you? Okay. Was it your child that was bullied?
That I told him.
Oh, okay, okay.
Oh, thank you very much.
Okay. Let's see, let me try. They're number 10. 10. How did you find out that your child was being bullied?
He came home crying.
Came home crying? Had it happened that day?
It happened.
Okay. What about of those numbers that I called? Is there anyone who found out maybe later? Like it had been going on and you found out later? Juror number 17?
Yeah, it was about 6 months later.
Okay.
9-year-old son.
And why do you think it took him so long to tell you?
Probably pride, shame, something like the same.
Okay, pride, shame, didn't want to say anything about it. So sexual assault is obviously, or indecency with the child is obviously different than bullying, but it's a lot of the same considerations. So he mentioned, pride, shame as reasons. How do you think that children react to being sexually abused?
Scared.
Scared.
They're scared,
Embarrassed.
Shame,
shameful.
embarrassed.
Juror number 2, they withdraw. Juror number 7, they're embarrassed.
Sometimes they act out.
Juror number 28, they act out. And how or who do you think a child will tell when they're ready to talk about it?
Somebody that they trust.
Juror number 19, a friend. Juror number
Friend.
11, you say teacher? Teacher. Counselor. Juror number 16. What about like peers their own age, maybe? We call that an accidental disclosure when they tell friends and then the friends tell a teacher. Are children likely to blurt everything out at once?
No.
All of the details?
No.
Juror number 1, why not? I'm just practicing for your interview. Why might a child not say all of the details at first?
They don't want to get in trouble.
They're
They don't want to get in trouble.
Yeah.
They're ashamed or scared.
I'm sorry.
Yeah.
Just one at a time, please.
Yeah, she has to be able to know who says what. So juror number 3, you said embarrassed. And juror number 5,
They'll get in trouble.
afraid they'll get in trouble. And then juror number 11, they might get blamed for something. Juror number 2, they may be confused. Juror number 7.
I think it's, in my situation where this happened, they don't want to get the other person in trouble because they have trusted the other person.
Do you think it depends on who is asking the details?
Yes.
Juror number 7. Who are they more likely to tell all the details to? A friend or an adult?
I think an adult.
An adult. What about testing the waters? Does everybody know what I mean by testing the waters? Juror number 9?
No, I do not.
Okay. Anyone know what I mean? Juror number 7?
You tell them just a snippet of the situation and to see how they react.
Okay, so maybe a kid who's scared of getting in trouble, right?
You could, hypothetical, you could use somebody else like, and just having this problem, so use a third party or somebody.
Right, so during number 6, they'll use a hypothetical to try to maybe shield themselves from some of that, right? So anyone here, having talked about some of the issues that says, what, if a kid is being victimized in that way, or being sexually abused, and they don't tell right away, then I can't believe what they said. Is there anyone who feels that way? Again, this is a safe space. We're just trying to make sure that this is the right case for you.
I think it could go both ways, because, something could have happened and they're afraid to say something about it. And you certainly can understand that being embarrassed or something. On the other side, you kind of maybe get a little leery of it because why are they coming out now? Say something about it because I got mad at that person. Oh, that's why I'm lashing out. I coached sports and girls teams for a while, and you know, it's one of the things that you don't want to be anywhere near with them alone without another person there with you, because you don't want them getting mad at you because they're not getting playing time or something and lashing out in the end of the thing. Well, you know, he did this.
Yeah, no, that's a great point. Anyone else been in a similar situation as juror number 6? You know, maybe you coach, you know, softball or whatever, and you have to make sure there's someone with you. No, I appreciate that response. Juror number 7?
Same situation. I am a coach and I coach co-ed sport tennis. And so I have boys and girls that I have to deal with. And so in situations where they don't like something, you're not going to get to travel that day or that week, and you just never know. And so I do agree. It just depends. There's extenuating circumstances that you.
Okay, and
Can I say just
Or something is
one-
misread.
one,
Okay,
just-
juror number
just
6?
not that it's right in either case.
Right.
Something happened, something happened.
Right.
But in some cases, are they saying this because something happened or saying this now because they're mad?
So what is the trigger that makes them say it, right?
Yeah.
But that's what matters. Juror number 7?
And I also would like to add that in the sense of, it may have been just a passing touch, so to speak. So like you're saying, it has to be something definite, like there was an intent.
Right.
In the regards of sometimes as coaches, you know, I may be hitting a ball at a kid and.
Yeah, no, there has to be
inadvertently hits
intent, and
somewhere
it has
else.
to be for the purpose of sexual desire. Okay. Now, one thing I asked, and I kind of changed, actually, I flipped the way I asked this question because so many people respond. Juror number 61?
I was just gonna say that in hearing various opinions and people, the system is not necessarily set up to advocate for survivors. So that comes into play as well.
Okay, that's an excellent point. You know, maybe they're afraid they won't be supported or people won't believe them. Okay, so juror number 11?
It also.
Who's the aggressor? Can you?
And be in a relationship with any.
Okay,
If it's best friend of a parent, God, they may not be so. Saying anything. Anything done, or if it's a person of power. It's different than the husband. You know, they have already.
Now, going back to, I kind of started to ask the question and I stopped. I used to ask how many people at the point friend or relative who has been sexually assaulted. I think people are more vocal about it. So now I ask, how many people in here do not know a close friend or a relative who has been sexually assaulted?
Actually assaulted or accused of sexual assault?
I'll ask that question next.
Okay.
Victims of sexual assault.
That we don't know that.
You don't know anybody. You're number 2, 3,
I don't know anybody.
6, 7, 13, 15, 16,
Oh, no,
20.
I do.
Oh, I'm sorry. Okay,
Sorry, I was.
not
Can
15.
you
or
please
16.
repeat your question?
Okay, who here, everyone's, I know it's hot, I'm sorry. Who here does not have a close friend or a relative who has been a victim of sexual assault? Does not. Juror number 1, 3, 1, 2, 3, 6, 7, 8, 13, 20, 22, 24, 37, 41, 44, 50, 53, 56, 62, 68, 69, 74, 74, 75. Okay, now who here has a friend or a close relative who has been accused of sexual assault? Or number 5, 6, 7, 15. Whatever accused means to you. If you've been told that this person has sexually assaulted somebody, I would consider that. 5, 6, 7, 12, 15, 22, 26, 27, 39, 40, 42, 45, 48, 49, 54, 63, 65, 73. Okay, of those that know someone who has been accused of sexual assault, who here feels that they were not treated fairly? Juror number 7. Juror number 65. Okay, and juror number 22. Juror number 7, how close was this person to you?
He was my assistant coach.
Okay. Was he prosecuted?
No.
Okay. Physical evidence in cases like this. When we have a child who has made an outcry that they've been sexually assaulted and there's been a delay, how do you think that affects any physical evidence that may have been there? Juror number 33. Hey, stand up.
I think it varies because I mean, the way technology is today, you can take clothes or you can take an item and get DNA and stuff.
Right.
If the child's too scared or just testing the waters or whatever, you don't have the whole story. You might not be able to get that even today.
Right.
So
Right, and people scared. The clothes might have been washed, right?
exactly.
Yeah.
Yeah.
Thank you. Juror number 19.
I think it also just depends on exactly what happened. It's, you know, they ejaculate on him, or was it just fondling?
Right, was there any kind of bodily fluid involved at all, right? If you noticed on the element, like you didn't notice because you can't do PowerPoint, but touching for indecency with the child by contact can be over the clothes, okay? So what physical evidence is there gonna be? Juror number 3, there might be DNA. Juror number 14, you're shaking your head no.
Yeah, there's not.
They're not gonna be. So does that mean we don't prosecute those cases?
Pardon of proof.
No. Is there anyone here, you know, understanding the reality of what that could mean, that simply, you know, can't convict without some kind of physical evidence? You need something, you need DNA, anything like that? Okay. I wanted to ask of those of you who
5
do-
minutes.
Gosh, of those of you who do know somebody who has been sexually assaulted, anyone here, the person you know who didn't outcry right away, or maybe even waited years? Juror number 10. How long did they wait? 20 years. And why do you think they waited that long? They were scared. Juror number 14.
Yeah, about the same.
Juror number 18.
Probably like 5 years.
5 years. And why do you think they waited that long?
I think she probably felt alone or scared.
Alone and scared. Juror number 19.
I waited 9 years.
And if you're okay with sharing it, why do you think it took you so long to tell people?
I don't get in trouble.
You thought you were gonna get, were you a child?
2.
21?
It was my cousin. She waited about 3 to 5 years because she had a child, so she didn't comprehend.
She didn't comprehend what was going on. How old was she?
I want to say she was around 3. and it somehow got brought up.
Wow, she was little. Juror number 23.
About 5.
Okay, she was embarrassed. Was she a child?
No, she was.
Okay, thank you. Juror number 28.
And she waited 2 years.
Okay,
She was just scared of the.
okay. Was she a child?
Yes, she was 11.
She was 11. Juror number 34.
She waited most of her, waited until her adult life to talk to somebody about it.
Okay. Thank you. Juror number 35.
It was myself. I waited a long time. I don't remember.
Mhm.
And I waited.
Okay. Thank you. I'm sorry. Juror number 39.
It was a couple of years and she waited because she was on vacation in Mexico.
She was afraid to tell anyone. Juror number 40.
You waited about 2 or 3 years.
Thank you. Juror number 43.
She waited until she was out of her parents' house.
Was it her parents? Thank you. And juror number 49.
It was 6, 7 years, and it was once the female was able to start reproduction. So that was, and the mother was being abused, so it's kind of a, do I tell them?
Okay. Yeah. Juror number 26. Did you have your card raised? Oh, you're just holding it. It's a fan. Juror number 54.
Maybe she waited about 7 years. A woman, she didn't think it was wrong. There was more conversation, more knowledge. She was, oh, that she should bring it up.
Okay. And why do you think she didn't think it was wrong?
It was a family member. They were very, that particular family member was very outgoing and just friendly.
Mhm.
So it was, it used to be something that
They were trustworthy.
Correct.
Juror number 11.
That weird. That she described her. He had written her.
Okay. Wow. Juror number 12.
I think that's like, she.
Okay, wow, thank you. And thank everybody. I don't think I have time to get up to everybody because I think I only have like a minute left. I do want to really briefly talk about the judge, talk about the one witness rule. Who picks where a person gets assaulted? Who picks it? The victim or the assailant? The assailant. And are they more likely to do it in a crowded hallway or in a bedroom where nobody else is? The bedroom. And if it's in a bedroom, how many witnesses are there? Right, the victim and the assailant, right? And so who here, if we have the judge already went over this, nobody raised their hand. But we have a child and the child is trustworthy. You believe them, their story makes sense, and you have no reasonable doubt of what they're saying. That would say, you know what? I believe that child beyond a reasonable doubt. I believe that all of the elements have been met beyond a reasonable doubt. I believe it. Suspend, it's just a theoretical situation, but you believe that child beyond a reasonable doubt has been touched and all those elements have been met. Who here would still say, I just as a matter of principle need more? Juror number, Juror number 7, oh, one second. 7, 21, 32, 34, 54, and 56. And was that juror number 12 that asked? So I'm saying this is a theoretical situation. The facts are very favorable to the child. They have a compelling story. You believe the details. You find them credible. You believe that they were sexually abused beyond any reasonable doubt. Okay. But as a matter of principle, you just can't convict, even though you do believe the person's guilty beyond a reasonable doubt. And it's only one witness. It's only the victim.
Okay, so I would convict the person that committed?
Yes, yeah,
Just,
based on the one witness. Can you do that?
All right, so everyone, It's the same example that I've given to you previously. One witness testifies. They're brought in. They swear they're going to tell the truth. I give them the oath. You believe them. There's no issue with credibility. There's no, were they wearing their glasses that day? None of that is present. They testify. You believe everything that they're saying. And it ticks every box. And it's not about this specific case. Remember, these are hypotheticals. So the question is whether or not you could convict someone if one person testifies, you believe them, no issue with their credibility, and they prove the state's case. That's the question.
Well, in this scenario, is there just one person testifying or is there another side that comes in?
Here's the hypothetical.
I'm not confused.
No. This is the hypothetical. Everyone listen to my hypothetical. Do not add anything to this hypothetical. Somebody comes in and testify. It could be Mother Teresa. It could be somebody that there is no issue with their credibility. Zero issue. You believe that they're telling the truth. There is not a reasonable doubt in your mind that they're being untruthful. You believe they are telling the truth. When they come in and say, this happened in Bexar County, you believe it. When they come in and say, this happened on, let's just say hypothetically, this happened on June 4th, 2019, you believe it. It could be a robbery. When they say, the person who's sitting right there, that's the person who robbed me. You believe them. When they say the person right there is the person who took the money from me, and this is how much they took from me, you believe them.
Based on that, I can't really say yes.
Well, that's the fact scenario. That's the fact scenario.
Yeah.
It goes back to if somebody is in an alley and they get robbed and there's only two people in the alley. There's the person who got robbed and the person who robbed them. And the person who got robbed comes in and says, this is the person who robbed me. It happened in this dark alley. There were no cameras there because there's no camera in the alley. And you believe them. The question is whether or not you can find a person guilty if you believe the complainant. Now, here's the thing. If you're saying to yourself, if a complainant testifies and you're saying to yourself, well, I need more, that means that you don't believe the witness and you have some issue with their credibility.
Okay, well, I mean, that's. I don't know why this is so tough.
Yeah. So that's the question.
If I believe them, then I'm going to, for a conviction.
All right. So that's the question. If you don't believe them, then of course you won't convict.
Enter number 9, you agree with your card? Okay, and well, you know, the defendant has an absolute right to silence, to remain silent.
Leave just one side without hearing. I
Okay,
mean, that's not why we're all here.
All right. So the time has expired.
okay.
Ladies and gentlemen, with regards to hearing both sides, the state has to prove their case beyond a reasonable doubt. The defense does not have to do anything. In law school, we were told that you could sit at the defense table and play crossword puzzles. You know why? Because you don't have to prove anything. Your client is presumed to be innocent. The state has the burden. Think of it as a set of weights. Let's say you have a set of weights and they weigh 20 pounds. Those weights, if those weights are the state's case, it always stays at the state table. The defense never has to pick up those weights to prove anything because they don't have to prove anything. They don't have the burden. They never have the burden. The burden never shifts to the defense. So the defense doesn't have to call any witnesses, none of that. Does everyone understand? All right, defense. I'm going to turn it over to the defense. Yes. All right, everyone. I know it's very hot. Is there anyone who needs a break to go get water or anything else?
No.
Oh, all right, that's a no. Number 44. All right, number 44, yes. All right, if they don't have any evidence. All right, thank you. All right, defense, you may start.
Thank you, Your Honor. Good afternoon, everyone. Thank you very much. I appreciate it. So as you heard in the introductions, my name is Leo Gonzalez, okay? I have these, we both sides have these forms giving information about yourself, your basically, you know, where you work, what kind of stuff you do, your experiences in serving as a juror, if you have children, things like that. So I believe it's only fair for me to give you some of that information so that way you know who I am, since I know who you are, okay? As I said, my name is Leo Gonzalez. I've been practicing since 2007. I was a prosecutor, actually in the DA's office here in Bexar County for a long time. I was actually a prosecutor in Nueces County for a long time as well. I have a lot of experience trying these cases, and now I have a lot of experience trying them as a defense attorney as well. Interesting thing about these cases is we never know what jury's going to do. So the only time we get to figure out the people that are going to decide these cases is during this particular time, okay? So when we ask you the questions that we do, we're not trying to be prying about the questions that we ask. We're not trying to get into your personal information. We're not trying to be nosy. We just want to know who we're going to have on this particular jury to decide this particular case, okay? So sometimes it may seem like I'm going over stuff ad nauseum, the way that the judge already did and the way that Brittany did as well. And it's not because we want to belabor any points, because we want to make sure it's clear we understand what your answers are going to be, okay? And part of that is, let's talk about the example of 12 Angry Men. For those of you that have seen 12 Angry Men, how does it start off when they first get back into the jury room? How are the jurors when they first get in there?
Ready to
But they're ready to get out of there, right? They don't want to agree with each other. They don't want to talk about anything. Let's just move it along, right? Well, you know, what do you think we want as jurors for the people that we select? What do we want you to do when you get back there? What does anybody have a suggestion? Juror number 2, what do you think we want you to do? Not just me, just me, but both sides. Do you think we want to have a quick verdict? Okay, okay. A fair verdict. Anybody else have a suggestion of what we want? 43?
A fair trial.
Okay. Anybody else? 31?
Actual consideration of what the evidence is.
Consideration of the evidence, right? How do you go about doing that? Discussion. We want you to talk, right? And right now, that's why I tell you that the people who are the quietest end up on the jury, because we don't know much about the quiet ones. So we ask you these questions to find out, get the information out of you. Because we know eventually you're going to open up. The longer you're with a group of people, you're going to start saying your opinion, saying what you think, saying what you believe. We don't want that to happen and to find out those beliefs in the jury room that may affect my client, Mr. Lemon. So that's why we go through the questions that we ask you. And that's why the state goes through the questions that they ask you. Couple things. I know it's already been asked, but now you've seen me standing up. Does anybody know me? Does anybody have a relationship with anybody at the Bexar County District Attorney's Office? Like, has a family member that works there, who knows somebody there, who knows the DA, Mr. Joe Gonzalez? Anybody have a close relationship with anybody at the DA's office? Okay. Does anybody know my client, Mr. Wardell Lemon? Okay. There's a couple of potential witnesses you may hear from. Madison Keeney, Linda Keeney, Justin Keeney. Does anybody know any of these individuals? There's some potential officers that may testify as well. Officer O'Brien and Salinas with the San Antonio Police Department. Does anybody know those? Which one? I can tell you that real quick. Alicia? No. And then some officers from the Harris County Sheriff's Office. J.M. Gabriel, Gilbert, last name Gilbert, and last name Gonzalez. Okay. As I told you, the process of the voir dire is going to be to find out who can be vocal and open-minded to this particular type of case. The job that you've been given is to take an oath to give true answers to the questions we ask. Okay, that's the oath you were taking already. You're going to be given a second oath if you're selected to be on this particular jury. And that would be to find a true verdict, to render a true verdict. Okay. Now, we're not trying to change your opinions or feelings. We just want to make sure we get all of the information about how you believe and how you see these particular types of cases. I understand when you hear certain questions from the judge, you're going to respond a certain way. It's the judge asking you a question. I'm going to tell you right now, there are no wrong answers. I'm not saying anybody has given a wrong answer at this point. My point is, it's a little different. It's like if your mom asks you a question, you're going to answer initially, oh, yeah. But you may have a different, because you're afraid of saying the actual, what you believe. So sometimes we go over those same concepts just to make sure we understand what you feel, okay? How many of you feel comfortable with discussing sexual matters with 11 strangers? A couple of you, okay? Now, part of that is because of the type of case that is, there's going to be things that are going to be discussed in this type of case that some people may not be comfortable with, okay? May be harder to talk about. As of somebody who's tried these cases, I'm used to saying the words vagina, penis, anus, things like that. For some people, they hear them, and just because it's nervous laughter, kind of giggle, get uncomfortable, kind of shy away from the actual conversations. Is there anybody here that feels like, hey, I want to be a citizen that can listen to these kind of cases, but that stuff makes me uncomfortable, and I don't think I can be fair in that type of situation talking about that kind of material? Does anybody here feel that way? Raise your card and hold it up, and I'll call your number, please. And leave it up until I call it, please. Okay, juror number 5, 8, 11, 13, 15, 19, 25, 32, 34, 40, 45, 53, 55, 56, 58, 59, 62, 67, 68, 72, 75, 74. I'm sorry, I flipped that back. Some of you kind of gave us this information about knowing somebody who was accused, or I'm sorry, a victim of a crime, okay? And Ms. Mitchell asked it a different way earlier. She asked, how many of you do not know someone? This question is going to be addressed to those of you who are or know someone who's close to you, family member or friend, who's been a victim of this type of offense, a sexually related offense. And my question is going to be not, you know somebody. My question is, who of here of you believe that you cannot be fair on this particular type of case because of that experience? And if you feel like because of that experience, either as yourself or a close family member or friend, I want you to raise your card if you feel you can't be fair on this particular type of case. And hold it up, please. Juror number 5, 10, 11, 12, 15, 16, 17, 18, 19, 25, 32, 34, 35, 36, 40, 45, 55, 62, and 67. Some of you kind of alluded to somebody who had been or directly said that somebody who had been accused of a crime. I want to know if anybody knows anybody who's been accused of this kind of crime. And when I say accused, I mean actually charged by a law enforcement agency. How many of you know somebody who's been charged by a law enforcement agency with this kind of crime? Not necessarily indecency with a child, but a sexual related offense. If you know somebody who's been charged, please raise your card. Juror number 3, 10, 11, 15, 22, 26, I got you, 27, 32, 33, 39, 40, 48, 49. So a couple things.
Excuse me, counsel.
I'm sorry, juror number 2. Thank you, sir. Thank you, Judge, for bringing my attention to that. You're going to notice when you come into the courtroom, we stand for you. You're going to also notice when the judge comes into the courtroom, we stand for her. She is the judge of the law in this case. If you're selected to be the 12 jurors in this box, You are the judge of the facts, okay? What does that mean? Mr. Gonzalez, I don't understand. How am I the judge of the facts? She's had law school training. She's had training in French. She just told us. She's has knows so much more about the law and what's going to happen. How are we expected to do the same thing? How do you expect to be able to judge that? How do y'all ever judge facts in your everyday life? How? Tell me. Anybody got an example? Juror number 31.
Best experience.
Experience. Observance. But what are the examples of you judging facts in your normal everyday life? Juror number 35.
My 12-year-old telling me he brushed his teeth and then I tell him blow my nose and it smells like hot dog.
So you use your experience, like you have it every day, right? Your kids, your coworkers, your employees, your employers, use those skills, make a decision as to whether or not somebody's telling you the truth, whether or not something's taking place. We're not asking you anything outside of that. Okay, does everybody understand that? Is there anybody that feels intimidated by the process or was coming in here? Okay. We heard a little earlier about, well, there's two sides to a story, okay? Now, technically, there are usually two sides of a story, right? Now, in a case where there is decisions being made about whether or not somebody committed an offense, there's guilty and there's, what's the other side? What is it?
Not guilty.
Not guilty. So it is possible for people to be found not guilty, right? And from what you've heard from the judge, how would it be shown that somebody's not guilty of an offense? What has occurred if somebody's not guilty of an offense?
All the boxes haven't been checked.
All the boxes have been checked, number 7?
Yeah, we're just saying state has proven.
State hasn't been proven its case. So that means that there's heavy scrutiny on what the state does, right? Does everybody agree that that's the way it should be? Does anybody that disagrees that that's the way it should be? And why do you think that's the way it is? I mean, if they're going to go through the trouble of taking a case to a grand jury and getting it indicted, don't you think that the citizens that get to make a decision about somebody's freedom, about whether they convict somebody of an offense, look at it very, very strongly? Does anybody disagrees with that? Okay. How many of you, I know several of you have served on a jury. How many of you have served on a grand jury? Anybody? Juror number 50? How long ago was that, ma'am? Okay. And so when you were on the grand jury, without going to like what exactly happened in the grand jury, did y'all have witnesses that you heard from?
No, no.
Okay, because it was a grand jury.
Yes,
A case will be presented to you
yes,
and you get to vote whether it's a true bill or a no bill.
yes.
Okay, so you don't get to hear much of, you only get to hear one side at that point, right? We talked about 12 Angry Men, and we kind of have, I'm gonna keep coming back to that because it's so appropriate for, and if you haven't seen it, please watch it. There's two versions, there's an old black and white version, and then there's a newer version that's in color. The first person that comes to mind is Tony Danza, but who's the boss, if you remember that, but that just shows my age, if anything. Anyways, I'm gonna go back to that in that when you're having these discussions, it's not a democracy. Like you get to decide on your own what you believe about the evidence. Just because juror number 20 believes one thing does not mean juror number 3 has to believe the same thing. Does everybody understand that? Is there anybody that has a problem with sticking to what their beliefs are, even though they might be in the minority of those beliefs? And say, you know what, Mr. Gonzalez, if I get stuck back there and I'm the only one that believes one way or another, but because everybody else is against me, I'm just going to fold so that way we can get it over. And that's okay. Hey, that happens. Sometimes you don't want to be a part of the process and you're just saying, you know what, I want to get this over with. We don't want you to do that, but it might happen. Does anybody here feel that way? Okay. You're number 22?
I don't feel that way, but I feel, if it were to come to a point where I didn't agree, that I was forced, not forced, like, I have to agree, given what was in front of me, like, that would make me feel. And like, it's not like I'm giving in, but it's like, what else am I supposed to do if everything in front of me is?
So you understand, everybody has their own individual truth. Every juror has to vote as to what they believe the truth is. A jury can only come to a decision that's unanimous, where each individual person has come to a decision beyond a reasonable doubt that they believe the state has proven its case. Okay? If you do not believe that, then that's your right to say, I don't believe it, and I'm gonna say, I don't think they've met their burden. Nobody else can force you to do anything, okay? So that's why I'm asking the question. Is there anybody that feels like, look, I understand, I wanna be in that position, and I'll hold to my guns, but I'm not gonna stay in that position if everybody else is against me, okay? And if you feel that way, let me know. No? Okay. Talked about the burdens of proof. You've heard beyond a reasonable doubt. And how many people have heard it in all the court shows, beyond a reasonable doubt, right? We talked about it earlier today. What do y'all, there's no real definition, but what do y'all think it means? Like, beyond, when you hear the words beyond a reasonable doubt, what do you feel? What do you think? Anybody? Juror number 19?
There's no doubt in your mind that that's what happened.
Okay, so there's no doubt in your mind, but the word says beyond a reasonable doubt. So you're not eliminating all doubt, right? Just a reasonable doubt. I always use the example of a philosophical question. If a tree falls in the woods, does it make a sound? I mean, typically it's going to make a sound, right? Now, what if you had evidence to say reasonably that somehow it was lowered to the ground and you make a noise? Would that be a reasonable doubt based upon what your experience is at that point? Right? There's another example that kind of floating around right now is, I don't know how many of you remember back in the 80s, before Tylenol bottles were sealed, there was Tylenol that was laced with cyanide. And there were so many people who died or worried about dying from taking those pills. Does everybody remember that? For those of you that are old enough, some of you don't remember it, don't have no idea what I'm talking about. They're like, my pills, I can't get to them ever, they're stuck in there. But before, they had a lock. They didn't have a lock on there. Now they have the wrapper and then you have to get through it. But somebody had gone through and put them in there and put them back on the shelves. People were buying Tylenol and dying without any knowing. But let's say you had a spouse at home that needed to take Tylenol for a fever, but this situation is going on. You have to make the decision whether or not to take the chance of giving them that or risk them dying. So you use whatever's around you. That's reasonable doubt. I have a reasonable doubt as to take it because all these other people are dying around me. Does everybody understand that example? It doesn't have to be all doubt beyond a reasonable doubt. And if you see doubt and there's a reason for it, then that's enough for you to find somebody not guilty. Can everybody agree with me on that? What if the state fails to meet even one element in its case? Is that enough for you to find somebody not guilty? Okay. Because somebody, what are you talking about, Mr. Gonzalez? How does that make sense? Well, because the state has a burden to prove each and every element beyond a reasonable doubt. But some people might say, well, they got 6 to 7, that's close enough. That's a good percentage. If we were playing baseball, I would take that hitting percentage all the time. No. Your duty says to hold them to beyond a reasonable doubt as to every single element. Is there anybody here that feels that they cannot do that? If they're close enough, then that's enough for them? Does everybody understand my question? Okay. You're number 44? Okay, you're close enough, number 44, thank you. Does the verdict of not guilty mean somebody's innocent?
No.
So what does it mean?
They did prove its case.
Okay, so you don't have to worry about whether or not somebody's innocent, but whether or not they've been proven beyond a reasonable doubt that they're guilty. Correct? Everybody agree with that? Is there a verdict of undecided? There is. Now, we want you to come to a conclusion. It's up to the state to prove beyond a reasonable doubt. As you've been told, we don't have to put on a case. We don't have to do anything, but we get to examine the evidence that they put on. If you can't come to a decision, whose fault is that? Yours or theirs? Okay, and if they haven't done it and you felt like you're not sure, is that okay? Is there anything that you've been told that says you can't come to that conclusion? Okay, so that is a possibility. Defendant has certain rights. Who cares about those rights? Right? Everybody should, right? Why should everyone care about a defendant's rights? That's right, because sooner or later, it could be you. It could be you having to answer an accusation. So that's why it's important to make sure that those rights are upheld. The defendant has a right to a fair trial, a right to fair and impartial jury of its peers, of his or her peers, a right to plead not guilty, a right to be presumed innocent. There's a presumption that starts in every case that this man, Mr. Wardell Lemon, is presumed innocent. The state then has to prove beyond a reasonable doubt each element to prove that he is not innocent and in fact guilty of the offense. The burden of proof never shifts to the defense. We never have to prove anything. Always on the state. I'm going to ask you a question right now, and I want you to take a time to think about it as I sweat. Sorry. Is anybody here, because of the situation that we're in, my client being charged with the offense, have a preconceived notion about the guilt and innocence of my client? And if you do, please raise your card. Juror number 56, juror number 58, juror number 67, juror number 75, juror number 25, juror number 11. Sorry, I went a little backwards there, but that's how they came up. Ms. Mitchell and the judge talked to you about the Fifth Amendment and some reasons why a defendant may not testify. Can anybody think of any? List any off that they can think of themselves? Why somebody wouldn't testify? Juror number 31.
They could accidentally say something that contradicts their lawyer.
Okay. Anybody else? 24.
Self-incrimination.
Okay. Any other reason? 64.
Oh, we can't hear you.
Can you stand up?
Oh, sorry.
Okay.
It can be hard to face somebody in that. Sorry.
So say it a little bit louder.
Okay, it can be hard to face somebody who did something.
And I'm going to use you as an example, but more for your voice right now.
Okay.
You may have a low voice, right? You may speak softly. And that may be hard when at the witness stand, right? You can have a seat, thank you. Coming here. Juror number 2.
It's just feel comfortable speaking in public.
Public speaking. Juror 53.
Sometimes what they say can be misinterpreted.
Misinterpreted. We'll go back to juror number 2, public speaking. Y'all know what the biggest fear in the United States is? Public speaking. Public speaking. You know what number 2 is? What? No. Somebody had something interesting to think about, but that's the other thing. No, somebody's standing over there. Dead. Right? So people who are usually at a funeral are more scared of talking at the funeral than actually being at the funeral. That's an interesting thing to think about, right? How that affects our minds. We come with peace in death, but having to go up and speak and do the eulogy at somebody's funeral scares us so much. So that could be a reason why somebody doesn't want to testify. They don't know how they're going to react when asked questions. And that's tough in and of itself. How do you judge the credibility of witnesses? Now, we kind of talked about it earlier when one of the moms talked about asking their child about brushing your teeth. So
5 minutes.
thank you, Judge. What do we use to determine if somebody's being credible? 23. Okay, emotion. What their possible motive is for speaking, for answering a question. If any of you were on trial for an offense such as this, how many of you would feel comfortable if you were convicted on just the evidence of one witness testifying? So you've heard a lot about this one witness rule and how it can be, state is definitely within their realm to prove it with just one witness. But as we heard here from juror, I think it was juror number 7, I don't know if I have a choice. Well, you do. If you hear everything beyond a reasonable doubt and it's still not enough from that one witness, and that's not enough for you to convict, you can still find somebody not guilty. That is your choice. Does everybody understand that? Does anybody ever believe that complaining witnesses lie about an offense that's been committed against them? Anybody? So does everybody think they always tell the truth about being assaulted? Right. Do children lie? And when I'm saying, and I'm not talking about offenses, just in general, do children lie?
Yes.
What do children usually lie about?
Everything.
And what?
6:30.
Whatever suits their need. What reasons do usually your children have for lying?
In trouble.
Getting out of trouble. So what happens? They get out of, how do they feel like they're getting out of trouble by lying? Shifting the blame.
Making themselves look good.
I'm sorry?
Making themselves look better, like good.
Does anybody think that these cases are ever affected by custody issues?
Yes.
I'm sorry, what was that? And why do you think that, juror number 57?
Because when parents are really angry at each other, sometimes children repeat what they might hear an adult say. It gets heated and emotional. It's hard to differentiate fact from emotion.
Couple of things real quick. How many of you watch, so the big thing used to be watching Law and Order, right? Now it's more about watching real life documentaries on Netflix, Hulu. Who watches those? Crimes that have been solved 20 years later, right? Why do these cases end up getting a story made about it? What has happened? Usually. What? More evidence. DNA. Technology. Sometimes it's just about whether or not there was enough evidence from the beginning, right? And so when you think about your verdict, I want you to think about, am I comfortable in this verdict that there's not going to be a documentary made about it in 10, 15 years of what's taking place? You should consider it that strongly, okay? Are any of you here feel you're better qualified to sit on any other type of case except for this type of case? And if you do feel like you're better qualified to sit on another type of case, please raise your card. Yeah, juror number 22.
I don't know if I feel better qualified or if I feel less qualified for this one based on my previous.
Okay, and that's what I'm asking. Based upon your experience, if you feel like you're better qualified to sit on a different kind of case, then let me know. Juror number 11, 12, 14, 16, 17, 18, 35, 45, 53, 55, 56, 13, and 5. Is there anybody here on this panel who, if they were in the defendant's shoes, would not want yourself on the jury? If any of you here were in the defendant's shoes, but you believe I wouldn't want me on this jury because I have such preconceived notions that would affect my ability to be fair to this individual. And if you do feel that way, please raise your card. Juror number 11, 12, 16, 17, 18, 22, 25, 34, 35, 36, 40, 45, 53, 55, 56, 58, 59, 62, 67, 75.
All right, that's
Thank you,
time.
Judge.
Thank you. All right, ladies and gentlemen, I'm gonna have you all step outside and I am going to call you back in at 4:45, and at that time, you'll know if you have been selected on the jury. Everyone, please take your personal things with you, but leave the cards behind. They're very expensive. They are.
Right.
In no particular order. Read them all in.
Just have a seat, just wait at the end.
But they
There's
don't,
no numbers,
but they
just
can't
have
come
a
over
seat
here,
anywhere.
so we have to make.
Yes, but you like, will always be.
No, I don't think so.
And everybody's gonna have a seat, no.
Okay.
That's where that time they get selected. Not everybody's gonna have a seat. Those numbers, just find a chair.
Doesn't matter where.
She she brings flowers every week. She has flowers every week.
Yeah. Just the bench. Just the bench.
I wish you could stand or like move around and all this stuff. Like that many people I couldn't see you.
I think not even gonna have to think so. That's it. Then everybody else come on in, keep on coming in. There's a seat over there. No, because there's some room right there in the middle.
Oh, yes. All right, everyone. I want to thank you all for coming down to serve. All right, if you all could please silence. I want to thank you all so much for coming down to serve on the jury. We cannot have jury trials without jurors. The 187th District Court is always open, so you can always come to court and see what is happening in the court system. Make sure that all of you have had your parking validated. If for some reason you didn't get a chance to have your parking validated, just let them know that you were in the 187th District Court. Deputy Mejia at the back has the white sheets. Those are sheets. Make sure you only take one. Those are sheets that signify that you are actually here in court today. With regards to those sheets, you can do one or two things. One, what will end up happening is you will receive a check in the mail and you will remember the beautiful hot day you had in the 187th District Court. And it will be enough for you to at least have a lunch downtown, not at the touristy spot probably, but you can have lunch downtown and walk on the river walk. I always wonder if people notice the great things that make San Antonio, or do we ignore it? Whenever I go to Paris, I always wonder, do people see the Louvre or they just, we see that all the time. So I always tell people, make sure to stop and smell the roses. So when I call your name, I'm going to ask that you take a seat in the box. You will be on the panel. Jennifer Nance. Megan Cochran. Michelle Jones. Alejandro Cespardo. Diego Fernandez. He already knew his name was called, but he just started walking before I even finished. Michael Price. I always mess up with my double L's. Joe Heston. It's a JH.
Yeah.
You know who you are. I'm working, the double L's always confuse me.
Thanks the first time.
Okay, now don't feel bad. Delia von Muldo. Reynaldo Gonzalez. Rebecca Snithen. Leroy Villarreal. Daniel De Harley. Christopher Estrada. Jake Perez. All right, so the good news is that we will have AC tomorrow. The bad news is we didn't have AC for you all. So if you make sure you grab the white sheet from Deputy Mejia, that will signify that you are here today and you are excused.
I know they're looking at the score. I was like, oh, she's looking this way.
Is Mejia out there?
All right, ladies and gentlemen, I'm going to give you your instructions. Yes,
Does your microphone go up just a little bit more?
I tell you, it does, but I tell you what, I'll speak louder. Is this a good tone for you?
I'm sorry, I wear hearing aids.
Oh, no, 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 no. I'm glad that we know that now. So everyone will make sure that they speak into the microphones.
Just yell
It will be a yelling in kindness. All right, so these are your instructions. Number one, I know it's hot in the courtroom. I have no control over the thermostat. We could bring a fan in, but if we bring a fan in, then the court reporter won't be able to hear because they don't have the fan that is a quiet fan. My understanding is there is something wrong with the compressor. So hopefully they are fixing that and we will have AC tomorrow. You are allowed to bring drinks in if you wish to. Just make sure it has a top on it or something. I know the chairs are hard. I've been slowly buying cushions for that. If you have a cushion at home and you want to bring your own cushion, you're more than welcome to do that. We're going to start tomorrow at 9:30. Here's the thing about the 9:30 start. This building, all of the people that you see in this building park at the parking garage. There are jurors that come down every day, and I think it's about 300 to 500 that come. They park at that parking garage. So if you want to be assured, and I say assured, 99% chance of getting a space in there, it would probably be best for you to be here no later than 8:30, even though we're going to start at 9:30. When you come back here tomorrow, you will not come to this courtroom. Deputy Laura will show you where you will report. You will report in the jury room that we have for the 187 District Court. It's towards the back, and Deputy Laura will show you where that is. We do take breaks. If you ever need a break, just do the break symbol. I'll see it, or either one of the attorneys or the deputies will see it, and they will let us know that you need a break. Do not be shy about asking for a break. We try to make it as comfortable as possible for you all. There is a refrigerator and a microwave in the jury room. So if you want to bring breakfast, lunch, you're more than welcome to do so. I try to end each day by 4:30 when I have jurors, so you can beat rush hour traffic. Here's the exception to that rule. I don't like for a witness to be called and only one side get to question them if both sides want to question them. So if it's in the middle of questioning, we'll finish with that one witness. I don't expect there to be any publicity in this case, but everything you need to know about this case is to come from inside this courtroom. If you see anything on the news or media about it, ignore it. If anybody wants to ask you about this case, tell them you can't talk about it. You can tell them, hey, I'm on a jury trial, but you cannot tell them about this case. Does everyone understand? So no investigation whatsoever. Do not Google any names. Do not do any of that. Let me see if there's anything else. All right. Any questions? Yes. When will this end? Is that your question? Okay. Yes. Yes. I knew that was coming. So I will usually know by tomorrow when I start hearing whatever evidence is presented, how long the trial is going to go. Believe it or not, when you all are hearing evidence for the first time, sometimes it's the first time that I've heard it as well. So I'm hearing the evidence the way you're hearing it, but based upon my experience, I'll be able to tell you tomorrow how long I expect the trial to go. Any other questions? All right. I normally say, bring a jacket, in case it's cold. I still say that because it's better to have it and not need it than to need it and not have it. And if you all want to bring hand fans and you have hand fans, be sure to bring those. I'll check to see if we have hand fans in the back as well, so that we can pass them out to you all. Is there anything else? All right. Deputy Laura will show you where you will start tomorrow. All right, we're not off the record yet. All right. And Travis, that's Ruben. Ruben, could you close that door?
Oh, right, I know.
Or didn't
So it's
you?
after.
All right. So is there any motion that I need to hear?
Please, so.
All right, anything that needs to be taken up before a start of trial?
We may have an oral motion limiting regarding criminal history, Your Honor, and other acts regarding. It's only to be pertain to the indictment, nothing else other than the indictment, what's in the indictment at this point.
Okay. And State, are you aware of any other acts?
Well, it's, in her outcry, it's to the effect of people touching it. So it's, and that is part of our outcry notices on file.
Nope.
But we can approach, I don't know how we would get around it because of the nature of the outcry.
Okay. All right.
And if I have an objection, Judge, I'll approach you and we can figure out what we need to do from that point.
All right. And who is going, State, are you planning on calling an outcry witness?
Yes, which is her stepmother.
All right. And unless everybody's going to waive anything, we'll need to have a brief hearing on that.
That's correct.
So is that going to be your first witness or no?
Usually I like to put the trial on just to cover The outcry is usually the child first.
All right,
so,
then.
But I was gonna put bio dad first.
All right, well, let's do this. If you're going to be calling the outcry witness, if you all can be here tomorrow at 9, and that way we can have the hearing with, in regards to the outcry witness. And I know it's sort of a little backwards because then you'll call the complainant and for her to say who is the first person she told. But what I can do so we can run and schedule if no one has any objections is that whoever you say the outcry witness is, we can hear their testimony. And then if the complainant testifies and says, the first person I told was this person, then I can make a ruling. Is everyone okay with that? Okay, and we'll do it that way. And there's only one outcry, is that correct?
There are two, but we're just doing one.
Okay.
So that's all we're gonna be looking at.
All right. And defense, you're aware of who this outcry witness is, the
Yes.
first one?
We've been given notice of that person.
All right, thank you.
Mhm.
See y'all then tomorrow at 9 a.m.
Yes, Judge. Yes, sir.
Yes.